Luke is organizing a trip to a rugby match. He collects £500 in cash from 3 friends, promising to use the funds strictly to buy tickets and hire a car. Later that evening, Luke sits down at a high-end restaurant and consumes an expensive meal. Only after finishing his dessert does he realize he is short on cash, and he makes a conscious decision. He will keep the £500 for himself and walk out without paying for the food. On his way out, Luke stops at the restaurant cloakroom to retrieve his own winter coat. The attendant asks for the required £2 holding fee, but Luke refuses to pay. He grabs his coat, violently shoves the attendant backwards to clear his path, and escapes out the front door. In a law exam, you will be presented with a scenario exactly like this and asked a specific question. Based on these facts, is Luke guilty of theft and robbery for the cash, the food, or the coat? Answering this question using standard moral intuition will lead to a failing grade. Securing a conviction requires a rigid, mechanical application of the UK Theft Act 1968. The legal framework begins with Section 11 of the Theft Act 1968, which states that a person is guilty of theft if they dishonestly appropriate property belonging to another, with the intention of permanently depriving the other of it. Looking at this statutory flowchart, the definition splits cleanly into 2 components: the physical act, or actus reus, and the mental state, or mens rea. Zooming out, we see these 2 components break down into 5 specific elements that must be satisfied. The actus reus requires 3 physical conditions. There must be an appropriation. The target of that appropriation must be recognized legally as property, and that property must be classified as belonging to another. The mens rea requires 2 mental conditions. The defendant must act dishonestly, and they must operate with an intention to permanently deprive. The application of this statute relies on the rule of simultaneity. The prosecution must prove that all 5 of these elements were present at the exact same point in time. If even a single element is absent, or if they occur out of chronological sequence, the charge of theft completely collapses. Examiners build their scenarios around these precise chronological misalignments. Section 3.1 defines the first physical element, appropriation, as any assumption by a person of the rights of an owner. To a layperson, stealing implies a secretive taking without permission. The legal definition abandons this entirely. And assumption of rights simply means doing anything to the property that an owner has the right to do, whether that is selling it, destroying it, or even just picking it up off a shelf. Historically, the courts conflicted on whether an act had to be unauthorized to count as an appropriation. The case of Morris suggested the act had to usurp the owner's rights, while Lawrence held that the owner's consent was irrelevant. This diagram maps DPP versus Gomez. A customer passed stolen checks to an assistant manager, who convinced the store manager to authorize the transaction. The House of Lords ruled definitively: appropriation occurs even with the owner's express authorization, provided that consent was obtained by fraud. The case of Hinks established that even receiving a valid legal gift constitutes an appropriation. While civil law recognizes the defendant as the new owner, the criminal law treats the acceptance itself as an assumption of the original owner's rights. There is one strict chronological boundary, established in R.V. Atakpu. Defendants who hired cars abroad using false documents had already completed the theft when the cars were acquired. Their later actions driving the cars in England were not new appropriations, because you cannot appropriate property you have already definitively stolen. Because the courts have defined the physical act of appropriation so broadly, virtually any interaction with property satisfies Section 3. Consequently, the legal battleground in an exam scenario will rarely be the physical taking. It will center on whether the defendant was subjectively dishonest. The second element requires that the appropriated item legally qualifies as property under Section 4.1 of the Act. The statute explicitly includes money, real property like land and buildings, and personal property, covering tangible objects. The Act also includes things in action, sometimes called choses in action. These are assets that cannot be physically touched but represent an enforceable legal right, such as a copyright or the credit balance in a bank account. In the Privy Council case of Chan Man Sin, an accountant forged company checks to illegally drain its accounts. The court held that by drawing on the account, the defendant appropriated a thing in action, the debt the bank owed to the company. The statute carves out highly specific exceptions. Under sections 4.2 through 4.4, land generally cannot be stolen unless you are a trustee or severing fixtures. Wild plants and wild creatures are also excluded unless they are taken for commercial reward or have already been reduced into someone's possession. These definitions create strict boundaries around intangible assets. In Oxford v. Moss, an engineering student acquired an upcoming exam paper, read the questions, and returned the physical document to the filing cabinet. The court ruled that while the physical paper was property, the student lacked the intent to permanently deprive the university of it. The confidential information written on the paper was not recognized as intangible property under the Act, resulting in an acquittal. Identifying whether a defendant has stolen a physical medium or merely copied the abstract data stored upon it is a precise discriminator that determines liability. The final physical element requires that the property must belong to another at the time of the appropriation, governed by Section 5.1. The statutory definition extends far beyond legal ownership. Property legally belongs to anyone who currently has possession or control of it, or who holds any proprietary right or interest in it. This creates the legal paradox that a person can be convicted of stealing their own property. Returning to Luke's scenario at the cloakroom, even though Luke is the absolute legal owner of his winter coat, he handed it to the attendant. Because the attendant exercised temporary control over the coat, it belonged to another for the purposes of the Theft Act. The restaurant meal presents a fatal timing problem. Under civil contract law, property ownership of items like food or petrol passes to the consumer the moment it is eaten or dispensed, as it becomes irretrievably mixed and cannot be returned. This timeline illustrates Edwards E. Dinn. We pinpoint the exact moment civil ownership transfers to the consumer, when consumption begins. When we overlay the moment the defendant forms their dishonest intent, we see a gap. The intent arises only after consumption is complete. Because Luke only decided to steal after he finished eating, the rule of simultaneity fails. At the moment he formed the dishonest mens rea, the food legally belonged to him. He is immune from a theft charge regarding the meal. Section 5.3 provides a specific criminal mechanism to bypass this civil law transfer. If a person receives property under a strict legal obligation to retain and deal with it in a particular way, the law dictates the property still belongs to the original owner. The obligation must be legally binding. In Huskinson, a man spent his housing benefit on himself rather than his rent. He was acquitted because the Social Security regulations imposed no strict legal ring fence on the cash. Luke, however, collected the £500 from his friends under a strict, specific agreement to buy rugby tickets and hire a car. Section 5 operates as a safety net. By artificially extending who property belongs to, it captures offenders who have acquired technical civil ownership but clearly committed a criminal wrong. Section 8.1 defines robbery. A person is guilty if they commit a theft and immediately before or at the time of doing so use force on any person or put them in fear of force in order to steal. This flowchart shows the rigid structure of a robbery charge. Step 1 requires proving a theft has been completed. Only after every element of theft is proven do we move to Step 2, evaluating whether force was used or threatened to achieve that theft. The most common error in exam conditions is observing a violent mugging and immediately analyzing the use of force. If the underlying theft is invalid, perhaps because the defendant honestly believed they had a right to the property, the robbery charge instantly fails, regardless of the violence. The statute requires the force be used specifically in order to steal. Furthermore, the violence must occur immediately before or at the time of the theft. Violence used hours later during an escape does not qualify. To prevent thieves escaping robbery charges by using violence moments after seizing an item, the court established a vital rule in R. v. Hale. The court ruled that appropriation is not an instantaneous event, it is a continuing act, and the jury decides when that act finishes. Robbery is a completed theft that has been elevated by the presence of proximate violence. Returning to our opening scenario, we can now apply the statute to determine Luke's final verdict. For the expensive restaurant meal, Luke is not guilty of theft. Because he ate the food before forming his dishonest intent, ownership had already passed. He failed the rule of simultaneity. For the £500 cash, Luke is guilty of theft. Although he acquired physical possession of the money, Section 5.3 maintained his friend's legal ownership because he accepted the cash under a strict legal obligation to buy rugby tickets. For his own winter coat, Luke is guilty of theft. Even as the absolute owner, the coat belonged to another under Section 5.1 because the cloakroom attendant had temporary control. Furthermore, the theft of the coat elevates to robbery. Applying the Hale principle, Luke's violent shove of the attendant occurred while the appropriation was still a continuing act, satisfying the requirement for force used at the time of the theft. Every conclusion here defies basic moral intuition. The result is achieved solely through the mechanical application of the statutory definitions provided in the 1968 Act. True mastery of property offenses requires stripping away emotion. The Theft Act is an engineered system, explicitly designed to selectively override civil law concepts to secure criminal liability.